subject to more than one interpretation is not proof beyond a reasonable doubt. As Mr. Kirby said in his opening, the evidence in this case is graphic and disturbing, and it is deeply sad. And I don't envy your position, Your Honor. The rest of the people in this courtroom get to be human. We can feel shock and outrage. But Your Honor, as the court, you are the embodiment of law. And as the court and the fact finder, the law requires that you not allow your verdict to be swayed by sympathy for anyone. It must be based on the evidence. Mr. Ibarra, acting on our advice, elected to have a bench trial, trusting that Your Honor could, and believing that Your Honor would, set aside the emotions in this case and simply consider the evidence. So I'm going to catalog for Your Honor why I think the facts and the evidence in this case should leave you with some reasonable doubt. Before I do, I want to touch on two legal principles. Your Honor is already familiar with them, but I do want to make my legal arguments clear for the record. The first legal principle is embodied in OCGA 2446. And that law requires that when the state's case is built on circumstantial evidence, they have a higher burden. They have to go one step beyond proving their case beyond a reasonable doubt. They also have to exclude, beyond a reasonable doubt, any other theory consistent with Mr. Ibarra's evidence, in a sense. Because the evidence is subject to more than one interpretation, it is not proof beyond a reasonable doubt. And while the evidence in this case is voluminous, it is circumstantial. The second principle is the difference between a party to a crime and accessory after the fact. This principle is codified in OCGA 16-1050, and I would also direct Your Honor's attention to Purvis versus the state. Purvis is spelled P-U-R-V-I-S. That is 208 Georgia Ave 653. And that case basically explores the difference between proving that someone is involved in a crime while it is committed versus proving that someone is involved in the cover-up of a crime. The important difference, Your Honor, is that if the evidence shows that Mr. Ibarra was involved in the cover-up of the crime, but does not prove beyond a reasonable doubt that he was involved in the murder itself, Your Honor would be authorized to find him guilty on the tampering with the evidence charge, but not with the murder. So now I want to talk about the evidence that was presented. First, I'm going to discuss the reasonable doubt in the state's case that Mr. Ibarra was involved at all. Then, I'm going to discuss two alternative theories that are consistent with the evidence that would show Mr. Ibarra is not guilty of the malice murder or the felony murders. And then finally, I want to discuss a few specific elements of a few crimes and the evidence we've heard on those. The state bases its case in chief on some categories of evidence. There's DNA, there's a fingerprint. They talked about the digital evidence and the surveillance footage. There is reasonable doubt in each of those pieces of evidence. I'll start with the DNA. There is doubt based on what was tested and doubt based on what was not tested. When Ashley Hinkle was on the stand testifying and Mr. Kirby was cross-examining her, she talked about the limits of her science. She talked about the fact that some of the factors involved in testing for DNA are controlled by humans and some are run through a program. She decides how many people's DNA is on an object and then asks TrueAllele software to compute from that number of people the likelihood of whose DNA that is. Her decision impacts how the test is run. She told you that there is an element of randomness in TrueAllele, and that if they run the same test multiple times, different probabilities will come out. And that's what happened in this case. Your Honor should be skeptical of the DNA evidence also because of something that Ms. Ross talked about. A hat that we know for certain was on Diego, a hat that we know for certain was his hat that he claimed. Nothing on that hat tested positive for his DNA, which goes to show that even if someone is wearing clothes, touching clothes, owning clothes, DNA is not always going to show up when the lab tests it. People in court wore gloves when they handled this evidence because they were afraid of cross-contamination. They were afraid that their touch would impact the reliability of future DNA tests. When you look at the apartment from which these clothes were taken, that is a lab tech's nightmare. There are clothes everywhere piled together. It's 5 people living in one room. And the state's theory is that they shared clothes. Of course their DNA is going to be on each other's clothes. It's more than possible that one brother's DNA would get on another brother's clothes. In fact, it's probable. And who would have had the most cross-contamination? Diego and Jose, because they shared a bed and they shared clothes. When it comes to true allele, I do believe our argument is hampered by not having an expert, but there are clearly flaws with that testing system. One of the tests that they ran for the evidence in this case came back to a retired GBA agent who was not involved with the testing of the case and was not in any way could have had their DNA on that object. There's also doubt based on what was not tested for DNA. There was a bloody thumbprint on Laken Riley's phone that they believe was placed there by the killer. And they chose, rather than swabbing that for DNA, they chose the less reliable scientific method of fingerprint evidence. There were no swabs tested of the phone, even though Saunders testified that they did take swabs. There were no swabs tested from Laken's neck and torso. But perhaps the most important is that they swabbed Jose Ibarra's hands and his fingernails. And their theory is that his gloves ripped enough for him to leave a fingerprint on a phone. That rip would have allowed him also to have contact with Laken Riley's body. And then, if they had tested the swabs on his fingerprints, we could have seen if Laken Riley's DNA showed up on his hands. But they did not. They don't get to cite a name of a guy we don't know, James Sebastian, and call it a day. They should have provided some reason why they didn't test these swabs, and they gave Your Honor none. They also didn't test any of the gloves found in Diego's bag. They had a visual examination, but we know from the state's own evidence that that's not enough. Katrina Ostapovich testified that she has to use a special light to see blood on objects. She called that light an ALS and compared it to a black light, because blood is not always visible to the naked human eye. So Saunders' visual examination of the gloves in Diego's bags should not persuade Your Honor beyond a reasonable doubt that they did not have blood on them. The fingerprint evidence in this case is also questionable. At the Daubert hearing, Tim Stewart testified about the APHIS database, and that is a federal database that stores any fingerprints deemed valid enough for comparison taken by federal agents. There are hundreds of thousands of people in that database. And Tim Stewart, before he did his own comparison, ran the latent fingerprint from the phone through that database. And there was no match to Jose Ibarra. He wasn't even in the 120 possible candidates that APHIS populated for Tim Stewart. I want to also speak briefly about confirmation bias. When we were speaking to the medical examiner, she talked about how when she looks at the case, there's information already populated in the system that she doesn't generate. The case number and the involved parties. And the involved parties in this case are telegraphed to the scientists at GBI as to how the state wants the evidence to come out. The information said subject Jose Ibarra and elimination Diego and Argenis Ibarra. And unfortunately, when you're testing for DNA and you know ahead of time the result you're supposed to get, that colors the process and weakens the scientific reliability of those DNA tests. Now, as the phone location data, their theory is that Jose had the phone. Agent Hipkiss testified that Jose is the user of the phone. Their evidence relies on the fact that Jose had exclusive access to that phone, but that is dispositively not true. Norris testified that other individuals were communicating with other members of someone using that phone in October. The stipulation of the parties showed that there were other accounts on that phone. There were 2 Gmails belonging to Diego, and there was some evidence that that email account was active in January of 2024, which is a month prior to this. Rose Bailey had a Facebook Messenger account on there. Jose's mother-in-law had a Gmail account on there. There are multiple Instagram accounts belonging to Diego on there. That's all stipulated. And even if you consider that Jose had the phone, the testimony of Jay Burney shows that there is some shakiness as to exactly where that phone was at the time of the murder. The broad band of where that phone could have been due to the delayed timing evidence of the phone is quite wide. It covers parts of the Laconia forest and parts that are outside the forest. He concluded that the user of the phone must have been in the forest because of the lack of Wi-Fi Reuben data, but he also conceded that that Wi-Fi Reuben data could have been lacking if someone turned off their Wi-Fi. That uncertainty as to what caused the Wi-Fi to not respond is reasonable doubt. In the dumpster video, Your Honor should have some doubt based on the angle and the quality of the video. Rose Bailey did identify Jose, but she testified that the reason she identified him was because of the hat and the shoes. The hat that we know Diego owns, and black slides that we know Diego owns too, because the agents found a second pair of black slides in the apartment when they searched it. So the hat and the shoes that Rose Bailey identified for Jose could just have easily been Diego's. In the 911 call, no one identified the voice. I don't know why the state didn't ask Rose Bailey, but she was here. Maybe she could have testified of who was speaking, but no one did. And the phrase that the state would like you to believe was being spoken, Yo Tango, was heard by somebody who does not speak Spanish. We don't know what is being said on that call. We don't know who says it. There is an alternative theory in this case that makes sense of some of the discrepancies in the state's case. Jose was short, he was chubby, he was, according to the state, wearing slides the morning of February 22nd. I agree with the state that Laken Riley was physically fit, she was fast, she could have outrun him. But there's another suspect in this case who was taller, who was more physically fit, who was wearing sneakers on the day of the murder, and that is Diego Ibarra. We know from the dumpster video that the person throwing away the jacket is tall, because Officer Zach Davis testified the slot into which the jacket was thrown was about 6 feet high. The person in the video didn't have any trouble, it was parallel to their head or just above it reaching that slot. That suggests someone that's taller than Jose Ibarra. We also know from Joseph Clemente that there was a second person out wearing dark clothing, not a runner, on the day of the murder. He testified that between 9:46 and 9:48, he saw somebody who was skinny, wearing dark clothing, wandering around the intramural fields, and was about 6'9" or taller. That description matches Diego to a T. And we know it can't be the same person in the dumpster video because it happens at the same time. The dumpster video is at 9:44. Clemente is pretty certain about his timeline because he's tracking his position using a running app on his phone. Other evidence that suggests Diego is the one who killed Laken Riley is, of course, that the fact he was wearing a hat with Laken Riley's blood on February 23rd. According to the state, you can see blood on black clothes, so Diego, when he's choosing hats that morning, should have been able to see that the hat was bloody. But more importantly, Officer Epps testified that he observed dirt on the brim of the hat. Tim Johnson testified that he observed dirt on the brim of the hat. There is no way Diego put on that hat without noticing something was strange about it. And the reason he put it on, without questioning why it's got dirt and blood all over it, is because he already knew that it was there. The state would like to say that Diego would have to be the dumbest killer in the world to put it on, but unfortunately for the state, that's exactly what the person in the dumpster video does. After he examines the hat, he puts it back on. So if their theory is that's Jose, or that's Diego, either way, the killer put the hat back on his head after having been committed in a murder. So that argument does not hold water. We know that Diego had 2 cloth gloves in his bags. Both of them are mismatched, meaning that, assuming that they each had a pair, there was a pair of gloves Diego owned that was never found. But while we're talking about gloves, I want to talk about the black gloves that were found in the apartment. We know that they were disposable kitchen gloves, and unfortunately we don't know where they came from because the officers didn't track the investigation that far back. However, Rose Bailey said that they did not come from Utaje, the sushi place where Jose and she worked. They did not come from the place that Jose Ibarra had access to. What we cannot rule out is the Bolton Dining Commons, the UGA dining facility where Diego worked. Why is that important? Because bringing the gloves home shows a step of premeditation. Who had access to do that? Diego. Why would he do that? Because he was planning to use the black gloves at some point. And speaking of gloves, why are there 3 of them found in the bushes? Jose has 2 hands, like everybody else, but there are 3 gloves, and they test all 3 and found presumptive blood on all 3 of them. What that suggests is that there were multiple pairs of hands wearing those gloves. Now, they did enter video evidence of Diego clocking in at work, but that video is not an alibi for Diego because his commute to work was only 10 minutes, and his clock-in time on February 22nd is 3:57, which is 6 hours after the murder. If anything, Diego's work schedule makes him more suspicious because the bus stop that he regularly takes to work is the one featured in the surveillance video near Saraswati's apartment. It is the same bus stop that the officer said they reviewed and never saw Diego. And we know that they should have seen Diego because he took that bus stop to get to work that day, which means the detectives never saw him because they missed him at least once, possibly more than once. We know that Diego's phone had no service, no location capabilities, and the agents testified that Jose's phone was a go-kart to Jose's race car. If Diego needed to use a phone with service, the phone was already logged into his Facebook, Instagram, and Gmail, he would have taken Jose's. The state argued that Diego didn't act suspicious. Neither did Jose. Both of them complied with police commands. Both of them answered questions and were talking, laughing outside the apartment. Officer Cyan testified that the vibe amongst all the roommates was relaxed. They were smoking cigarettes. You can't assume anything good from Diego's behavior on February 23rd that you can't also attribute to Jose. But it goes beyond the possibility that Diego was involved. Diego himself multiple times confirms it. First, by threatening Stephanie Slayton. Now, Ms. Slayton has no incentive to lie, and the state did a lot of work trying to make her look uncredible. And I like that the state is not about shaming females until they're testifying in a way that complicates their evidence. Because they tried to use her sexual relation with Diego to implicate her involvement. They've tried to shame her for celebrating her birthday. But the truth of the matter is she was scared and she came forward to the police anyway. She talked to them multiple times. She offered to let them download her phone, even though she was fearful of retaliation. Those are not the actions of someone who is making something up. In the context of that conversation that Slayton was talking about, she tells Diego, I know you're in that area a lot. You must have seen something. You should tell the police. And that's when he said, if you tell them that, like I was in the area and I might know something, I will tell them that you did it and then I will kill you too. Why is the two important? Because it's implying that he has already killed before. But Slayton is not the only one who has heard statements from Diego that implicate his involvement. Your Honor is aware that there are inmates who have heard Diego say that he was wearing the blue jacket on the day of the murder, that Jose threw it away in the dumpster, presumably for him. He told them that Jose didn't do it, and the police weren't looking carefully enough at the evidence. He put himself on the scene and told those inmates that he saw Laken Riley's body. Your Honor, it's obviously good to be thinking, well, how did Diego then not show up in the DNA evidence? He might have. We know that there were multiple male profiles on the straw. They said it couldn't be a blood relative because of a YSTR straw, but we know that Diego was not a YSTR comparison from the fingernails. So that could have been Diego on there. And as Ms. Hinkle said, the absence of Diego's evidence is not evidence of Diego's absence from this case. Some of the minor profiles on the gloves and the hat were not identified. And the true allele ratios that the state relies on said that the DNA was more likely to be Diego's than Arhannes'. Another theory of the case that is not excluded by the state's evidence is that Jose was an accomplice after the fact of the murder. Maybe it was him throwing away the jacket, as Diego said. Maybe he was covering it for his brother. Maybe one of the two men in the area went to the dumpster, and one went to the retainment pond at 9:46, which is where Joseph Clemente saw somebody standing. Maybe one of them dumped clothes in a dumpster behind the apartments, and maybe one dumped clothes in the woods, where Officer Krischer found clothes exactly in that area that were not tested because they didn't fit the simplistic narrative of the state. Maybe there were two men involved in covering up Laken Riley's body, which is why there were 3 gloves recovered in the bushes. 2 people wearing 2 gloves. And we just don't know what happened to the 4th. To explain why there are 2 rocks in this case. We know that Jose was looking for Diego on the morning of February 22nd, because Agent Hipkiss testified that at 2:30 in the morning, there's a missed call from Jose to Diego. So there is some evidence that he was looking for Diego. The Spanish phrase in the 911 call could be Yo Tango, but it could also be the name Diego. That could be Jose saying his brother's name. Under that theory, of course, Jose would be guilty of tampering, but that theory does not prove that he was present or involved in the murder of Laken Riley. I want to speak last about 2 specific charges: aggravated assault with intent to rape and the peeping Tom charge. Their basis for concluding that the aggravated assault was intent to rape was the state of the clothes and the markings on her body. But Maxwell, the officer who found Laken Riley, testified that the area where he found Laken had vines and thorns. He testified about those catching on his uniform as he walked around looking for her. And they also, so it could have been that she was cut up by the vegetation in the area. We know that she unfortunately was dragged at some point because the scene where the blood is separate from where her body was found. So the scratches could have come from her being dragged to another area. And we also know it's unlikely to have been the scratches of her assailant from the fingernails, if that assailant was Jose, because when Daniela Stewart went to take his fingernail clippings the day after the murder, they were too short to take any clippings without having cut into the quick and being very painful. So it's unlikely to have been Jose's fingernails that caused those scratches. We also know that she had bloody marks on her ankles that didn't correspond to the wound, which suggests that somebody with bloody hands grabbed her ankles and used that to move her. And that could explain how her clothes were pulled up in that dragging position. We know that there was a struggle. We know that Miss Riley fought. Somehow her clothes could have ended up twisted in that struggle. And lastly, the intent to rape is a very specific intent. It's not just an intent to sexually assault someone. It's not just an intent to look at someone. It's not just an intent to expose their breasts. It has to be the intent to commit the legal definition of rape. And in this case, there's no evidence of trauma, according to Dr. DeMarco, of anything like that having happened or even attempted to happen. As far as the peeping Tom, the only part of the evidence I wanted to highlight for Your Honor at this point is that when Ms. Saraswati identified someone looking into her apartment, she said she never saw any part of his face, only the rim of his hat. So I think there's reasonable doubt that someone was actually able to look in. It may have just been the hat that was visible to Ms. Saraswati. Just one moment, Your Honor. Evidence that is subject to more than one interpretation is not proof beyond reasonable doubt. I would remind Your Honor that even if you think the alternative theories of the evidence are less likely, but they present any reasonable doubt, you would still be required to find Mr. Ibarra not guilty. We ask that Your Honor apply the exacting standard of the law to these facts and find Jose Ibarra not guilty. Thank you.